Good afternoon and welcome to the Appellate Division, First Department. We have 4 hours of requested argument time, so please ask for the time that you need, not the time that you want, knowing that we are familiar with your briefs, the record, the appeal, oftentimes more than you wish we were, and know that the time is for you, not the court, so that if my colleagues have additional questions, notwithstanding the time, I let the clock run, okay? All right. People versus Jared McGowan. Wrong calendar. You got it? 4 and 1 and 3. Two Cap Investments versus Frog Investments. No, you scared the appellant away. How much time would you like, or would you like to submit?
Well, I can still argue it.
Yeah, of course.
All right, I guess maybe just 6 minutes.
Okay, there's nobody here, so I'm going to give you 4 minutes, and if we have questions, we'll pepper you, okay? All right. S. Lulu versus Ramal H. is a submit. Promenade Nelson Apartments versus New York State Division of Housing.
For the appellant, 6 and 2.
Okay? 6 and 2 and 5. Mevram Services versus Quadrum Hospitality. Okay?
Respondent, 10 minutes.
5 and 2 and 6. You weren't listening. Okay. People versus Juan Cordero. Okay. Let's do 5 and 1 and 5, and I suspect we're going to get to 6 with the questions, okay? All right. People versus Eric Daniel. That's a submit.
Certain underwriter.
Did I miss one? I'm certain. Sorry. Certain underwriters at Lloyd's versus Izaka Nisanoff Inc. Sorry. Okay. 5 and 2 and 4. Thank you, gentlemen. People versus Eric Daniel. That's a submit. Staff versus Luen Nam Realty. Okay. 6 and 2 and 6. JLJ Productions versus Amazon.com.
5 and 2 for appellant.
Okay.
5 for respondent.
5 and 2 and 5. People versus Donald O'Toole. Okay. 5 and 2 and 5. First case on the calendar, People versus Jared McGowan. You may proceed.
May it please the court, Alec Mirren for Mr. McGowan. Mr. McGowan's 9-year prison sentence should be reduced because of the sincere remorse that he has expressed and the insight he showed into what he acknowledges are very serious offenses. Mr. McGowan expressed his deep remorse at the time of sentencing and wrote a private letter to the victims in this case. These offenses coalesced around co-occurring mental health and substance use issues that directly contributed to this offense. Speaking, though, first about Mr. McGowan's remorse, he has never disputed the severity of these allegations or these charges that he pled guilty to. And as I mentioned, he wrote to the victims at sentencing, and he expressed at sentencing that he knew in his actions he had perpetuated the same harm that had been done to him.
Also, based on his criminal record, and based on the fact that he stabbed 2 people and then fled the jurisdiction, don't you think 9 years is sufficient?
These are very serious offenses, Your Honor, and there are a couple of things I would say to that. He does have a criminal history. I think the thing to focus on here, though, or the thing that's very important, is that from 2009 up until
Defendant
September.
himself was ready to take 10 years, which had been the people's offer at sentencing, at the plea, counsel asked, basically, can you do better? And the judge gave the defendant a year less, but he was ready to agree to 10 years.
Absolutely, he did express that, and there are a range of sentences, though, that are available, and this court has the power, when looking at all of the information.
So, and in that regard, right, he was facing up to 50 years.
I believe it is 40 based on the capping because of the...
Okay, so 40, and he got less than 25% of what he could have gotten. You're still seeking further reduction.
Yes, Judge, we are seeking for...
So four felonies prior to this.
And as to remorse, I'm sorry.
No, and multi-state convictions plus parole supervision violations, correct?
Yes.
You're still seeking less of a sentence?
Yes, Your Honor.
Also, the second victim had a punctured heart and collapsed lung that requires surgery to repair. That's just one.
Absolutely, and I think what's important to point out here is, again, Mr. McGowan expressed remorse for the harm that he caused and the injuries that he caused. As detailed in the PPI that was submitted and is part of the record, he pointed out that this section of the offense is one where his trauma and his substance abuse were very much triggered, and that he accepts and admits and wants to make up for the harm that he caused there. But this was a situation where he was on the ground, and as detailed, he has a significant trauma history that extends to his childhood. And
But he was on the ground because he started the fight. So he can't initiate a violent exchange with another person. That person is entitled to defend themselves, and then attempt to use that attempt to protect oneself as a basis for, I'm entitled to do what I did.
Nobody is saying that he is entitled to do what he did. That is not what Mr. McGowan ever expressed or meant to express. Just that the escalation of this offense was a situation where he was, as the PPI noted, triggered in what was a fight or flight response. And when Mr.
Counsel, this started because he was denied service at a bar.
Yes, and he has been very forthright with the
And then he
social...
waited outside the bar for more than an hour until the bartender with whom he had gotten into a dispute, because the bartender wouldn't give him any more to drink since the defendant was drunk. He waited outside of the bar for him for more than an hour in order to get the bartender.
And then he fled to Virginia. And a month later, when he was finally caught, he denied involvement. So the whole remorse factor is born of an afterthought. True?
I would say that obviously, yes, when he was arrested, he did deny responsibility, but as he sought out mental health treatment in Rikers, as he worked with his attorneys on this case, this is a process. And the insight that he showed into what led him to do this, not to excuse anything, but to understand what led to his conduct that he acknowledges was harmful, that is a process. And where he got to by the time of sentencing, I think, is what speaks about the insight Mr. McGowan has. And I think, as the court was asking about his criminal record, shows his sign of success that he has had in the past. From 2009 to 2021, there were no offenses. He worked, tried to open a business.
I'm going to let you talk a little bit more about that on rebuttal, because you have a little time there, and we're over this time, okay?
Understood. Thank you.
No problem. You may proceed.
Good afternoon. May it please the court. Margaret Crookston for the people. Your Honors, this sentence was fair and appropriate. It was negotiated, and as noted, he was willing to accept 10 years.
And that sentence was reduced by 1 year because of the mitigating factors that counsel has just
Yes.
correct?
Yes. So the facts
So he
that
did get a sentence taking into account all that mitigation.
yes. So the same facts that are raised on appeal now were included in that pre-pleading memorandum, which the judge then noted and said that he had read and was willing to give 9 years in light of the information included in there. As Your Honors noted, this was incredibly violent. The two victims suffered very serious. One of them had to have life-saving surgery afterwards.
They both require surgery, correct?
Yes, yes. And the first victim, the bartender, was unable to continue his job after his hand was injured so badly. And as noted, he did lie in wait. This wasn't a momentary lapse in judgment or a fight. He did have an hour to not follow through on his threat, and he chose to wait and attack not only the bartender, but someone who came in to try and help.
So a good Samaritan got hurt too.
Yes, yes. So if there are no further questions, we ask that you affirm.
Thank you. Counsel, you have a minute.
Thank you. Just to sort of wrap up what I was saying before and respond, Mr. McGowan has had a period where he was in a much more stable situation, and he has shown that he can do that. This was a situation where, as the PPI and the brief noted, 3 months prior, he had been stabbed himself. That triggered significant acute mental health issues, and it triggered his substance abuse issues in a very, very serious way and undid his stability. He has shown incredible insight into what led him to commit what he admits freely are very serious and harmful offenses. And he has stability now with that knowledge, with his mental health diagnosis, to seek outpatient treatment and make amends, as he said he wanted to do, to make the necessary changes in his life at sentencing to go forward and make amends for the harm that was caused here. But if there are no further questions, I would ask the court to reduce his sentence in the interest of justice.
Thank you so much. Two Cap Investments LLC versus Frog Investments. You may proceed.
Thank you, Your Honor. If it may please the court, my name is Jeffrey Underweiser of the law firm of Underweiser and Underweiser LLP, and we are counsel for the respondent in this case, Two Cap Investment LLC. Your Honors, the case before the court is a very straightforward case. The defendant appellants purchased an apartment. They used an LLC to purchase it, all cash. Then they drew money out of the apartment by borrowing against it as a cash infusion to another business. And then the loan was refinanced. It was refinanced to my client, and they did additional loan documents, and the loan ultimately went into default.
Counsel, you would agree that the court below afforded your client the right to resubmit a motion for summary judgment. All the ducks were lined up. The paper trails support the 1.8 million mortgage default. We're all good, right?
Yeah, absolutely. Yes,
And you want us to affirm?
absolutely, Your Honor.
Okay,
So I guess that's it.
thank you so much.
Thank you, Your Honor.
All right. Promenade Nelson Apartments versus New York State Division of Housing Community Renewal. You may proceed.
Good afternoon. My name is David Cabrera, and I represent from the law firm of Bora, Goldstein, Alschuler, Nahans, and Goydell, and I represent the appellant, Promenade Nelson Apartments. We are stating that the DHCR improperly disallowed work related to the replacement of a very unique pedestrian concrete walkway.
Because they say it wasn't necessary, right? Some of the work, you spent approximately, in round numbers, $8 million and and there's no question that the money was spent. This isn't a case in which there's a question, do we have canceled checks, supporting? There's no question the money was spent, and you're allowed in round numbers, again, around $6 million for the MCI. And the $2 million, which is disallowed, is because they say it wasn't necessary. Is that right?
Correct.
So what is it that they're saying wasn't necessary?
Well, it's several areas. There was a playground. There was electrical work. There was irrigational work. There was lighting. The lighting was denied because DHCR said it went beyond the scope of what previously existed.
So let me just ask you something. Of that, you put in some expert testimony saying that some of it was COVID. What did you say was COVID? All the electrical work?
The electrical work relating to the lighting. So, for example,
And the DHCR refused to look at them.
correct. And what they put in was they installed these lights were affixed underneath the concrete.
They put it above.
So they had to rip out the old ones. They put in new ones. They're LED. They're more efficient. That's what's required by the code. Also,
And
on
how
the
much of the 2 million is that, approximately that?
I would have to look at the
If
record.
you don't know, it's fine. I
don't
just
know.
thought maybe you did. Okay.
The playgrounds, I thought was absurd. The playground,
Is the playground also referred to as the amenity area?
there's different
I'm looking at the
areas.
pictures, and I'm trying to figure out where.
So it's located right across, it's next to the Spuyten and Duyvil Creek, overlooking the practice fields at Columbia University. It's built on a ravine. It's a concrete cantilevered out, and it supports the building. Underneath it are garages. And the size, when you first walk in, first there's a walkway over 100 feet that was replaced, concrete. And to the side, they have tennis courts, basketball courts.
And those were all there previously.
Previously, and you had to remove the lighting. But what they did do, and what DHR objected to
Was the
is,
promenade allowed?
excuse me?
Was the promenade allowed? Did they allow the promenade?
Yes, they eventually, because at first they denied the sections of the basketball courts, the tennis courts. They denied the fees from Metro North because they had to supervise and make sure that nothing was falling on tracks.
Mr. Cabrera, so to clear my head, I'll round it a little more than my colleague. About $9 million you sought. The DHR disallowed about $4 million, and then through the process of first Article 78 remand, they put back in about roughly 2 million, 6 million, a little over 6 and change. Again, forgive me for rounding it off, but I just can't be that precise right now. So what I'm focused with is the argument your friend is essentially making, that one of your central issues, as my colleagues raised, was that the argument that much of the work had to be co-compliant as per your engineer, correct?
Yes.
And they claim it was a new argument not raised before the agency, but first raised in the Article 78 below. That's not accurate, is it?
That is not accurate. It was in the initial record, subsequent in all of the.
It was in a record by somebody, a Miss Beck.
Miss Beck.
And am I right that your client was basically in the dark? They had a denial without any kind of indication what the basis for that denial was, and your client had to seek a FOIL request in order to understand the basis of it, correct?
It was pulling teeth, correct, Your Honor.
Right. And so since you were unaware of what the basis of the decision was, there was no way for you to oppose it and come forth with the necessary information required for a court to consider, since your clients were in the dark about the basis for the decision. And have I misstated that?
No, Your Honor.
Okay, so then on appeal, their argument that this is a new argument by you kind of begs the question, how can you argue something you're not aware of?
That is correct.
Okay, I think I got it.
Just one final point, but on remand, particularly a January 23 letter that was written, you make a specific point of saying the work was necessary to be co-compliant. You were pretty expressed in that letter.
Correct.
That was before the agency, before the Article 78, this Article 78, correct?
I think there were two submissions from Miss Beck. There was one during
You'll-
one of the
continue.
remands, and then a second one.
Well, the second one was from Ms. Lenthal, I think.
Oh, that was, I think, the original that had gone in. That was, I think, the engineer who was involved with the work from the very beginning.
Okay.
Okay, thank you. You'll have time on rebuttal.
May it please the court, I'm Robert Embarrass. I'm of counsel to Mark F. Palomino, who's the counsel for the respondent, New York State Division of Housing.
We see a fair number of these cases, and frequently, there's a question, was the money claimed to have been expended even expended? There's no question here that the petitioner actually expended these funds. What's the public policy consistent with the mission of your agency in disallowing these improvements
The policy, Your
in
Honor,
which,
is
it really just seems, in which looks like the petitioner was looking to do a decent job as they made these repairs and replacements.
the policy, Your Honor, is that there's a distinction between major capital improvement and service. And conceitedly, the concrete platform.
What was wrong with the basketball court? Why shouldn't that have been allowed?
I believe the basketball court was allowed, Your Honor.
Ultimately, he had to fight for that.
Well, it was a question.
He had to fight, no question. He had to fight for that. He had to seek a re-argument, a reconsideration. That costs money. On top of the $9 million they already spent. Counsel, as my colleague has alluded to, what are we doing? Are we sending a message to landlords across this city and state that they should not make improvements to their property because now the legislation is going to not allow you to recoup so that children will not have safe playgrounds? What are we doing? How does this further public policy that a landlord who actually does the right thing, fixes his property properly, enhances it, makes it better so that it's safer for the people who use that building? And what do we respond with that? We cut them off at the knees and don't let them get reimbursed for the obvious improvements that they've made, not just to their building, but to the quality of life of their tenants. So what is DHCR doing here? I don't see how this furthers public policy. If we say what you want us to do is okay, what landlord is going to ever improve outdoor space for its tenants ever again? Please explain that to us. Because I'm not the only one who is concerned about the message that this case would send.
Your Honor, there's a distinction between ancillary necessary work that was.
So then, if that's gonna where you're gonna draw the line, how can you argue code compliance is necessary? And that you're not gonna look at it, that you're going to not look at it because the petitioner had to get documents, had to do a FOIL request to get documents to figure out why you're doing all of it. And then when they went back, the hearing that you did was so tight and so cramped that you wouldn't allow them to put in the documents that would show that they were doing work to make the place code compliant. How can you justify that?
I mean, you seek to excuse yourself on this with a preservation argument?
Preservation. Yeah, Your Honor, that's correct. We are not on this appeal. We are not maintaining the contention that that the appellant did not raise the code compliance issue. The code compliance issue was concededly raised during the PAR, so we've abandoned that contention.
So why did you not pay for code compliant
Work.
The letters from Ms. Beck made generalized statements about code compliance. There was no specific factual information about in what respect these particular installations didn't comply with current codes, nor were there citations to codes. So it was, what you're asking us to do is to credit generalized statements.
You give them no basis for your denial. They have to FOIL request why you've denied them, and we should hear you to complain that they don't give you sections. That's what you're arguing. We can tell them nothing. We can deny and say absolutely nothing. They have to seek court recourse in order to get the information they need to appeal. And we should get caught up on, there wasn't a tight section? You didn't even give them a reason.
Your Honor, in the PAR, both the original PAR and the remanded PAR decision, those did give reasons.
Very generalized reasons. There would have not been a need for a FOIL request, and they asked for the information, and it was not forthcoming, and they had to do a FOIL request to get the information.
Your Honor, the FOIL request was made contemporaneously with the PAR, and the agency responded to it before the issuance of the PAR. So they were given reason. They were not given. Conceitedly, they were not given reasons in the original RA determination.
So one second, you said that in denying the code compliance, the DHCR stated certain features needed to be upgraded in order to be code compliant was improperly raised.
Your Honor, as I answered before to Justice Friedman, we are not maintaining that contention on this appeal. We are not claiming that this issue was improperly raised. We're saying that the submission by Ms. Beck was factually and legally insufficient or inadequate. But we are not saying it was. We are not maintaining.
So you're not making a preservation argument at all?
No. We have abandoned that.
Where did you find that in the below? Where was that in your denial of the text?
Your Honor, it's not. No, it's
It's
not.
not. It's not there.
No, it's not. In the
It's not.
determination.
This is something new on appeal, right? You didn't deny for that because of the generality in before the agency, did you?
No, Your Honor. The
Okay, so then,
determination-
so
no.
you did deny, right?
But we're conceding that the determination was erroneous in that respect.
So at a minimum, we've got to remand.
So wouldn't it have made sense for you to call your adversary under these circumstances, particularly when due process is so critical here, to stipulate? Why didn't you go outside with your adversary, stipulate remand, and develop a better record here? Because it doesn't make sense, not only public policy, code compliant. This buildings and the property was in the 20th century. We're now in the 21st century. We constantly have to upgrade to comply with electrical codes and all the various
Disability
codes.
Act. I mean, there's a bunch of things that change.
And it's for the safety. I mean, when I think about the fact that they improved the lighting for the tenants in the public spaces, that's a safety issue. That's for them, for the environment. It just doesn't make sense for you to just knock off $3 million.
We did stipulate to one remand, Your Honor.
You did.
Right.
So no more? So we did it once, we can't do it again, even if we're wrong?
Well, certainly if that's the court's determination to
I'm so
remand
glad
it
you
for
said that.
redetermination, we will
Thank
not
you so
contest
much.
that. Thank you, Your
Look
Honor.
forward to seeing you back.
Thank you.
He still has a minute. Would you like to exercise it?
I would just ask that the judgment appealed from be reversed, that the matter be remitted to DHCR to grant the MCI application, which was sought in the Article 7.
Or for a hearing for them to determine the issue they failed to consider?
Yes, Your Honor.
Thank you. Mevram Services versus Quadrum Hospitality.
Good afternoon, Your Honors. May it please the court. Robin Silvermans for Appellants, Quadrum Hospitality Group, Arlo Soho, Arlo Nomad, and Arlo Midtown. Your Honors, this case stems from service agreements that were entered into.
And which your client breached. You did not give them notice that you were terminating the contract according to the terms of the contract.
Your Honor, we're not here to argue whether or not our clients breached the contract.
No, we're going to argue, we're going to discuss what this court thinks is important. And we start there, right? Because your client breached the contract. And now your client, on the basis of another statute, is trying to do a workaround, right? By saying, oh, we had to. Except that you started by violating the contract by not giving notice of termination of the agreement, correct?
Yes, there was not proper notice given, and that is an issue that's going to be litigated as this matter continues, because this was just a partial motion. There's no contention here that those issues don't stand, and there are defenses on those issues as to why that notice wasn't given that we intend to put forth as the case proceeds. What we're here today to discuss is just the anti-competitive provision in the contract, to say that that is not valid because that violates the New York City's displaced
Were they
buildings.
displaced? How do we know that, since the company you hired, when you breached the contract and didn't give notice of termination, and you hired a new company, and they then hired all of your former company's workers in violation of your contract?
So, Your Honor, just at the text of the statute itself, I think is.
I know what the text of the statute says.
Yes, going back to the statute itself, the statute contemplates this same scenario. It applies to service contractors. So whenever a service contractor is going to be terminated, the successor contractor needs to maintain those employees that were working.
And what proof do we have that they were going to be terminated?
Once the contract, it doesn't say once they were, not that the employees were going to be
So
terminated.
you're saying that your client entered into a contract agreeing not to poach his management company's workers, and did so knowing, oh, I'll just use this statute that allows me to hire someone else, and because those workers can't be displaced, I'll have them hire them, and I get around this contract provision
That I agreed to.
Agreed to as a sophisticated party.
Yes, Your Honor, I understand that that is what it looks like.
Oh,
However,
that's what it is, not what it looks like.
our client was dealing with 32 employees that they were concerned that they would have claims against them for back wages, reinstatement, liquidated damages, attorney's fees, and costs. The statute doesn't contemplate this scenario where they may or may not be displaced, or we have to rely on the prior service provider.
I guess the problem with your argument, for example, is you didn't have to agree to that. You did. So you can comply with the statute. All you have to do is pay the amount of money that you said you would under the contract. There's no violation of the contract. You have to pay for complying with the statute. That's all. You didn't have to agree to that, but you did.
Right, and Your Honor, we did cite case law, Your Honor, it was cited case law in our brief that.
You didn't have to retain prep hospitality services either.
They were providing the same services that the prior contractor
Right, you
was
could have
providing.
continued to live under the contract that you had entered into. If you didn't want to terminate it pursuant to its provisions, then you should have continued with that contract. You didn't have to go to someone else.
The reasons that the contract were terminated were issues that we were going to litigate in the underlying litigation.
No, but here, the problem with that is that you're arguing that you were forced to violate the statute, or but you weren't. The statute, you comply with the statute, you pay under the contract. That's all there is. There's nothing against public policy for you to comply with the statute and pay your counterpart under a contract that you agreed to. Those two things are not mutually exclusive.
Right, but the statute itself in that provision, the anti-poaching provision, should be void as against public policy because it did require them to violate that provision.
No, it didn't. You have not established in this record that those workers were displaced. No way, no how.
Your Honor, respectfully, if they were not displaced, any service contract that is terminated, we would have to make the assumption that we would not offer employment to those individuals, that they would be retained by.
Perhaps if your clients had not violated the contract and breached the contract and spoken with your, with the service people that you had, you would have known that they had jobs for them.
Okay. Thank you, Your Honor.
Timothy Crampton on behalf of plaintiff respondent Mevram. I think I can keep this fairly short. Based
Well,
Well-
I don't think, I have to ask
Don't
you
assume
about that.
anything. It's your turn.
Because, you know, there is, I think, a legitimate concern about punitive damages or damages that are obviously it's a pre-answer motion to dismiss. But I'd like you to explain where your damages calculation accurately reflects the damages that would occur because of the breach.
well, as liquidated damages.
Yeah, that's what I'm asking you.
Yes, those come from the costs that Mevram would incur from losing a substantial portion of its workforce.
Except it didn't, right?
It did. They were poached.
No, but you're saying you could have placed them somewhere else, right?
Yes, there were open positions.
So.
So those 32 that got poached, though, could not be reassigned to other jobs that your company had.
That's correct. If they had not been poached, if the contracts were terminated and they had not been poached,
You could have put them in other jobs,
yes, there would have been open.
and now you couldn't put people in other jobs because you didn't have those 32 people. Is that it?
I think.
So your damages would be how much you would cost, it would cost you to hire 32 more service workers.
That's
And
one.
you're saying that that equals the 52,
No, it's 500,
520.
say $25 an hour at a minimum
Right.
for 520 hours. for
Which is
32
3 and a
workers,
half months.
About $400,000.
It's 3 months and 1 week precisely. It's 13 weeks of work for people who make $25 an hour thereabouts. Am I correct? We're not talking hundreds of thousands of dollars here.
It is hundreds of thousands of dollars. I think. I think it comes out to over 300, 400,000. But
So presumably your damages would be how much it would cost you to hire someone else and place them. And so it's your position that it would take you 3 months and a day to hire another porter, because that's all you get.
well, it's not just the cost.
Yeah, that's what I'm trying to figure
It's
out.
not
What
just
else?
the cost of
It's
replacement.
not one
There's
person.
also
You had
lost
to hire- You
business
had to hire
opportunities.
32 people. You had to hire 32 people.
Yes, we had to hire 32 more people. You have to fill those roles. You have to train those people.
I
There's
would
also
imagine you have to vet them, right?
Yes.
There's like a hiring process that most companies go through, and that costs money.
and
So it's
Mev-
not just the hourly wage we're talking about if you lose 32 workers at a clip.
Yes, there are also potential lost business opportunities because we don't have the proper staffing to.
One generally doesn't get, as we both know, lost profits on a breach of contract claim. So my question is, your training costs, training in what way?
Training.
I mean, they're porters, they're people, they're building service people, right? You're saying that you need to train them in what?
I mean, these are high-end hotels that they serve.
And you're sending these people into these hotels to do housekeeping type of services.
Not necessarily. Two of these contracts were engineering contracts.
Okay.
Only one of them was janitorial.
But anyhow, you're sending these people, and you say into high-end hotels. You have to be sure that the people that you're sending in are going to be able to perform the jobs that are expected at a high-end hotel.
And that they've been vetted.
Correct.
Because high-end hotels don't want to have questionable people with questionable backgrounds in their space.
There's a reason that companies like defendant hire staffing agencies because it is not easy to find qualified, trained employees. That's why they outsource that work.
And it's your position that, at least for this pre-answer motion to dismiss, you're going to be able to put in evidence that shows that number approximates the cost.
Absolutely. I would also say that just in terms of the actual standard here, when you're looking at
Thank you.
liquidated damages, this court has found grossly disproportionate liquidated damages at like 7.5%, while in other cases they have found that liquidated damages provisions between 2 and I think even up to 4 times the actual loss were reasonable. It's a very lenient
Depending on a pleading
standard.
motion, we can't make this determination. This is not something which we can determine on the pleading motion, can we?
I think that's a fair point, and also the inference goes in favor of the plaintiff on the pleadings. And so to the extent there's any doubt here, that doubt should be...
And this provision was negotiated between two represented parties, sophisticated parties. Am I correct?
Correct.
And the standard when we're dealing with sophisticated parties who are represented by counsel is pretty high.
Correct. And also to that point, and going to some of the questions that you were asking earlier, just on the point of defendants argue that the statute, that they were compelled to violate the statute, as you indicated, no, they weren't. This was, if the statute applies and if someone's going to have to bear the loss some way or the other, this is contractually shifting those costs. That's what it is, nothing more.
Thank you.
That is all. Thank you. We ask to affirm the decision.
You have 2 minutes on rebuttal.
Thank you, Your Honors. Just on the issue of the penalty provision and the liquidated damages, we've argued in our papers that it is a penalty. We concede that if there is a finding that the contract was breached, that they can seek their lost profits. We're not denying that. We're saying that the formula set forth in the contract is actually a penalty.
The formula that your clients agreed to with counsel and negotiated. Now you're having second thoughts after you intentionally placed yourself in this position by breaching the contract and not giving the notice that was required under your agreement. Because you could have easily given proper notice and eased out of this contract without this issue. Instead, you chose to just breach the contract, hire a new person, and have them come in and swoop in and steal all of their employees in violation of your contract, explicit contract provision.
Yes, Your Honor. The reasons that the contract was terminated, like I said, we were going to litigate that. There were issues where, and we have defenses that there was an initial breach by the other side, and those are issues that we are not here to argue before Your Honor, so I don't think it's proper to get into it.
But also, even though whether or not the liquidated damages are an improper penalties, how can we possibly decide that? Counsel's made some good arguments. We can back up every one of those costs as being related to.
Well, part of the formula, the 520 hours, it doesn't account for what the actual employees would have been paid. So
what? A breach of contract is what I'm out of. So you got to wait till the end to see if that. This is it's actually a post answer, 321187 motion, but we can't tell that now.
yes, thank you.
Thank you. People versus Juan Cordero. You may proceed.
Good afternoon. May it please the court. Alexandra Ricks from the Office of the Appellate Defender for Juan Cordero. The 3030 court erroneously excluded 161 days.
How do we get, before we even get to the 3030, how do we get past this incredibly efficient, detailed waiver?
Your Honor, we may.
I mean, if you can't get past this waiver, there's nothing to talk about, right?
Yes,
Right?
Your Honor, and we
Okay.
maintain that the waiver was invalid for the reasons that we outline in our brief.
This
and
is,
I think
we have listened to this exact waiver several times, and it's one of the best waivers we see. So I mean, I've got to tell you, and I've seen some bad waivers. I would agree with you, okay? This ain't one of them.
Well, I would say that in light especially of what is a particularly egregious 3030 violation, and where it's not clear that Mr. Cordero understood that he was waiving his challenge to this speedy trial issue, the waiver is not valid. The prosecution.
How is it not clear?
Yeah, please tell us.
So first of all, so when we look at the rights during the colloquy, the rights that were waived, the court was very, she said twice her discussion of the waived rights. She said, you're waiving suppression claims, you're waiving excessive sentence. And of course, I understand there's no there's no requirement that they list every single
Again,
right.
what is bad about this? If there were a couple that were highlighted, there is no requirement that every single right that is retained be stated in court. There's a written waiver here, so what is unclear?
Well, while it's not a requirement, it
And
is.
the written waiver specifies the statutory speedy trial. Right, I would just add to Judge Scarpula's question.
Yes, absolutely. I will address all of these. So it's not mandatory to list every right, but it is, we're looking at the totality of the circumstances. The model colloquy suggests that trial courts list the heavily litigated dispositive issues that the defendant is waiving. It did not do so here. So that is one factor
So why
amongst the
doesn't
totality.
the written waiver make up the even if there was a problem, why doesn't the written waiver obviate that problem when it specifically mentions the statutory speedy trial right?
Right. So we know that a written waiver doesn't necessarily cure a deficient colloquy. We argue this colloquy was deficient because it was missing that. But here, the written waiver says that you waive statutory speedy trial, you retain constitutional speedy trial. There's no indication that Mr. Cordero, who is a lay person, would understand the difference between statutory and
So your argument, so wait, I want to be clear. Your argument is that now we should impose upon our judges that wherever there has been a speedy trial motion that has not been decided, they are required to say on the record at the time of plea that in addition to all of these waivers we've told you about, by the way, you have this speedy trial motion. If you take this plea, that gets waived. They have to explicitly say that. Is that your argument?
I would emphasize that the model colloquy suggests that for speedy trial claims in particular, the trial court do just that. But I would say that it's especially true here where...
No, wait, 1 second. May I interrupt you and say, on the record, defense counsel also confirmed that he had advised defendant that there were certain constitutional rights that would survive the waiver. Defense counsel told your client that there were constitutional rights that would survive the waiver. Confirm that on the record. So where is the ambiguity? Where is the we don't know? There's literally, unless we would have defense counsel state on the record exactly what he said to his client, which is no, we can't do. What more can we ask?
Well, I would say that saying that there are constitutional rights retained doesn't mean that she advised him what was waived. But I would
So what, we're asking you, what, because you're asking us to expand on what the case law of this jurisdiction is. So I want to be clear on what it is you think we should be doing. It seems to me you're saying that if there was a pending speedy trial motion that wasn't decided, that a defendant needs to explicitly be told by the court that, by the way, that undecided motion, you're waiving that too. Is that what you're saying?
No, Your Honor. We're asking you to adhere to the totality of the circumstances rule. And I think a relevant circumstance here is that the litigation in this case was about the COC, was about 245, which were new concepts. They litigated over this for years because the prosecution's COC was so deficient and was filed without the exercise of due diligence. And so in a situation where we're talking about this 245
Counsel, but
violation...
now you're talking about not... What you are suggesting, right?
Yes.
You're saying the court now, in the middle of a plea, should say, by the way, I see this legal issue about, because your attorney has made some arguments that they didn't properly file their certificate of compliance, and that has an impact on your speedy trial. The judge is supposed to engage in that kind of counsel with the... It seems to me like that's the job of his lawyer.
But to be clear here, it wasn't an open speedy trial litigation. There was a speedy trial motion. It was decided. There was a motion to re-argue. This
Exactly,
was
but
extensive.
when I asked you, what is it that you want us to hold? Do you want us to hold that if there's an open speedy trial motion, the court should advise the defendant that the openness of that will not be considered on appeal if you take this plea? And you said, no, not that.
I think
Right?
that it-
So I'm confused.
I would ask,
I'm not being hard on you. I'm
understand.
trying to understand what it is you want this court to hold.
I think that where there's been a dispositive issue that was heavily litigated, that the court should make the defendant aware that he's waiving that. In addition, that the court should not list retain or waived rights as an exhaustive list where that's not the case. I'm asking that this court consider also that the plea colloquy having him admit guilt happened before the court even explained what an appeal waiver was. All of these factors together, not any individual one,
So that third one, we've already said, doesn't go anywhere, right? So that's, and we're not going to revisit. The first two, you're saying it's not enough for counsel to say on the record, I have told my client about the constitutional rights that he still retains. You're saying that's not enough.
No, Your Honor.
And you're saying that the waiver, the written waiver, that the court confirmed with the defendant, his lawyer went over with him. I will give you a minute. I can read right from the transcript.
Yes.
Here's the waiver. I'll give you a minute, defendant counsel, to go over it. You're saying even that, which actually does list it all, is not enough.
Or the combination of both.
So to each of those, I mean, the court never even asked Mr. Cordero if he understood the written waiver. Yes, it's true he talked to counsel about it, but the court asks him, did you understand how I, the court, and your attorney explained it to you? And when we look to how the court explained
Why isn't that enough?
because the
The
court,
way I and your attorney, why isn't that enough?
because the court's colloquy was very limited in terms of what he was waiving, and because counsel's explanation about what she explained to him was only that he retained constitutional rights, that does not indicate to us that he had an understanding that he was giving up this dispositive claim that was quite egregious. And if I may address that on rebuttal.
You'll do that on rebuttal.
Thank you.
Good afternoon, Christopher Marinelli for the people. I'd just like to add about the waiver. I mean, the defendant does swear under oath to the court. He understands the waiver. He has no questions about the waiver, and he had ample opportunity to discuss it with his attorney.
And you know what? Look, that's there. But having been engaged in this dance, I know that, you know, a defendant is in the middle of a plea and all of this is like, you have cancer. You know what I mean? It's like just shock, right? So beyond that, does our record have enough to establish that the waiver was valid, that he was advised of all of his rights, both by the court and his own counsel, and the written waiver? Am I missing something here?
No, absolutely. The waiver covers it all. You know, there is, it's mentioned, it says right in the written waiver, statutory speedy trial. You know, I think, you know, in that case, the idea that, you know, this
Has
was
there
a heavily-
ever been a case that says that the court is required or that this written waiver should explain in granular detail the difference between a statutory speedy trial issue and a constitutional speedy trial issue? Is there any case that speaks to that?
Not to my knowledge, Your Honor. The court's actually held that the court doesn't have to make an exhaustive list. It says in Roulette, you held that, you know, a court doesn't have to plumb, you know, what the defendant's has a subjective belief that some claim might be surviving the waiver. You've also said you're not going to assume.
So if we you know, we've gone over the waiver, and you know, look, it looks like a pretty good waiver. I'll say that much. But if we were to get to the merits, what justified not charging the people for the period of October 18th, 2021 to January 14th, 2022, a total of 88 days, while you were responding to the 3030 motion? Didn't you take too much time there? Shouldn't that period have been charged to the people.
Well, of course, the court did charge us some time for delaying that response. I think that
Until
was
December
reasonable.
2nd.
Right.
December 2nd, right.
I mean, I think that was a reasonable exercise of its discretion. The motion court was in the best best position to determine what was reasonable under.
So what about
the
from December 2nd to January 14th,
Yes,
which would add 45 days?
right.
So what justified charging that to, not charging the people for that?
Well, I said it was within the court's discretion to essentially grant us a 6-week extension to file our response and then charge us for the additional 6 weeks. I mean, I will say within the speedy trial context, and I think this is, has been pointed out by about 30 many times, it's trial readiness,
Counsel, the court gives you a motion schedule to follow on a 30-30 motion. You don't follow it for 3 months. And the court's statement is that it was not trial posture ready?
And the court, again, did sanction us for part of that time, which, was reasonable and within its discretion as well. I would say, 30-30 doesn't actually go to, the people's trial
So the
readiness.
people cannot respond to a 30-30 motion for a whole year and not be charged?
No, I'm not saying that at all. The court did charge us. I'm saying I have seen cases where, cases have gone to trial with a 30-30 motion pending because it doesn't affect the people's trial readiness or even, the defendant's trial readiness. And it's, and also given the fact the defendant didn't even, in his motion papers, allege any chargeable time, I think the way the motion court resolved that period, from the original date to the filing of the motion response was reasonable.
Well, a valid waiver of appeal prevents us from looking at that.
Yes, Your Honor. Thank you. If there are no questions, we'd ask you to affirm.
Thank you. Counsel, you have time on rebuttal.
So as your honors were discussing, the prosecution, in response to the 30-30 motion, did not request an extension and get an extension. It showed up to court on decision date twice without having filed its response as it was required. That's 45 days that should have been charged. And in addition, the 161 days that the court excluded should have been charged both because the prosecution's certificate of compliance was filed without them having exercised due diligence. The court below recognized that their explanations about what they had done were blanketed descriptions. They hadn't exercised due diligence. And moreover,
The defense preserved that by arguing that their statement of readiness was illusory?
yes, they argued that the certificate of compliance was invalid and that the accompanying statement of readiness was illusory. And
Were there any affidavits during the time period when they delayed in responding to the 30-30 that explained the delays, like the court reporters aren't responding, I haven't gotten the transcripts, anything like that that would normally allow for the exclusion of that time? Was any of that presented to the court?
no, Your Honor, I believe at the very end they said they had a hard time figuring out what went on, but there was no real explanation of why.
What went on?
Went on during the case.
Okay.
Thank you.
Thank you. Certain underwriters at Lloyd's versus Itzhak Nisanoff, Inc. A little better?
Much better.
Okay.
Thank you, Ron. May it please the court, I'll keep it brief. And by brief, I'm just going to state that the fundamental question is whether Lloyd's can deny coverage to an insured for failing to maintain an approved alarm system.
Well, the court below, in the transcript, really analyzed the language as a whole and recognized that the burglar alarm system, just by the totality of what was expected here, included the surveillance. I mean, that's a critical piece of information. Would you agree?
Well, I would agree that the lower court lumped in or treated as one integrated system, a system involving a burglar alarm and a camera, but that's not what the policy called for.
Well, it had 3 parts. It had locks, working locks. It had the audio, and it had the video, correct?
Well, by audio, I assume you mean...
I mean the alarm,
Yes.
the alarm part.
So you are correct, yes, Your Honor. The lower court indicated that they felt because the cameras were not operational, that my client did not have an alarm system that complied with the policy. We maintain, of course, that that was an error because the policy language.
Why is it an error? We have a theft of a flying 29.8 carat diamond that flies outside of a box and can't be found in the room it flew out of. That's the story.
That is the story.
And
That is
yeah, it's pretty incredible.
well, whether it's
So those cameras would have been really, really helpful to capture this flying piece of rock that can't be found later.
well,
Especially for your clients who've been in this business for 50 years, counsel.
so with respect to the cameras in question, the flying rock. as you say,
That's the kind that
flew-
happened in Mumbai, right?
Mumbai. That was in Mumbai.
Is there any proof of that?
We maintain that there's a video that demonstrates that
You
the
didn't
box.
produce that video.
That is correct because that was not the subject of the motion.
Oh, that is the entire essence of this appeal.
It's the essence of the case. I would agree.
Yeah,
100%.
so why shouldn't we have it? I think it is conspicuously absent.
Because this is an issue with relation to disclaimer, whether a policy of insurance applies or not.
So it's interesting in reading your brief, you defend this, your position on the terms of certain underwriters. You throw in that this diamond disappeared in Mumbai, but there's no proof of that. Now, of course, if you had presented proof that this diamond in fact disappeared in Mumbai, one's outlook on the case might change. But absent such proof, you're left with the fact that the cameras are off for a month, and it's pretty hard to see that the cameras being off should comply with the alarm and protection clause of the insurance policy, as it appears on page 102 of the record.
So I don't disagree that if the video was part of this record, the court would be able to determine whether or not there was some factual basis to whether
There's
the.
nothing would have stopped you from making it part of the record.
It shouldn't be part of the record because it's an issue of fact, and that issue of fact is irrelevant to the motion itself. The motion relates to.
And if
whether or
we
not it was
disagree,
affected
But this is a motion for summary
then,
judgment.
then you die on this motion, right? If we disagree and think that that was absolutely relevant and is missing here, then there's no basis to give you any relief.
Well, I disagree because I think that's a fact issue for a jury to decide.
But this is a motion for summary judgment, so it was for you to lay bare your proofs. So if you had proof that this diamond disappeared in Mumbai at the customs office, that would certainly be a pertinent fact to raise on this motion.
I don't agree, Your Honor, because this is a policy disclaimer. It's either the policy applies or it doesn't, regardless of whether the stone was in
Yes,
Mumbai
well, then
or
if you
not.
get to the policy disclaimer, how do turned-off cameras comply with the alarms and protection clause of the policy?
Well, the policy language is so fatally ambiguous. It doesn't talk about an integrated system. It doesn't require cameras. It says
I don't
that-
know any luxury jeweler in New York City, and we have the Diamond District, right? That sets diamond prices and is like the center of this trade that doesn't have alarm systems that rival Fort Knox.
So I don't disagree, Your Honor.
Yeah, you can't get in one door without that door locking before you can get in the second door and the third door and the fourth door. That's how serious security is taken in the Diamond District, just not too far from here. And so you're saying that your clients not having operational cameras while receiving a 29.8 or 28.9, I forget, forgive me, carat diamond, that's not a violation of the policy here.
Correct, Your Honor. I'm saying that the policy language is
Doesn't the
fatally
fact-
ambiguous because it
the
doesn't
fact-
require cameras.
Doesn't the fact that you had cameras indicate that they're part of your alarm system?
No, it doesn't. Cameras are for video surveillance. A burglar alarm can have a ringing bell.
And
That's a burglar
also
alarm.
for evidence, so that if there is a heist, the police department and the insurance companies who are insuring very valuable goods have some evidence to assist them in trying to recoup, but you will have time on rebuttal.
Thank you. Thank you,
Even
Ron.
if we granted you that the cameras are not part of the burglar system, then why doesn't it fall under subdivision D of the Alarms and Protection Clause?
The argument is an approved alarm, a burglar alarm system.
All other protections provided for the safety of the insured property. You yourself provided cameras, but you don't have them operating.
All other, what does that mean? It's ambiguous. It doesn't specify. And to be fair, Your Honor, this policy says it has to be an approved burglar alarm system, and this carrier
We're not
never
talking
sought
about
to
the
inspect.
burglar alarm system now, we're talking about subdivision D.
So, that, Your Honor, that could mean a bear trap. I mean, honestly, it's
Because a bear is going to come into a jewelry store. Counsel, let's not make ridiculous arguments. You'll have time on rebuttal.
but it's not. It's all.
You'll have time on rebuttal. Thank you, sir.
Yep.
Good afternoon, Your Honors. Chanach Sheps for certain underwriters. My learned counsel is spending most of his time talking about causation, but this is a contracts case. It's not about substantial compliance. It's about what the Court of Appeals in Oppenheimer held is that non-performance of a condition precedent is an absolute bar to coverage, full stop.
So when it was admitted by Mr. Nisanoff in his deposition that his whatever, where he was, testimony was taken, that he conceded that the alarm, the surveillance was not working for a month, that was a clear breach of the condition precedent.
Absolutely, Your Honor. And it's
And you fully reserved your rights as you were investigating this, so you clearly deny that there was any disclaimer or waiver.
Yes, Your Honor, and there are no disputed facts, as the Nisanoffs admitted and adopted the Rule 19A statement submitted by certain underwriters in support of its motion, starting at page 69 of the record, which included not only the examination under oath testimony, the deposition testimony, 2 notices to admit, which all center around the fact that there was no working system at the time of the loss in August of 2017, that it hadn't been working for over a month, that the stone was in the office for 1 to 3 hours on the date of loss, which conveniently, as Your Honors have pointed out, would have captured the activities of the insured at that time. And the clause is written in the conjunctive. All of these conditions have to be met. It's not about substantial compliance. It's clear as day, and for what it's worth, the clause explicitly states that it is a condition precedent to the liability of underwriters that the insured comply with it. There's a lot of case law about whether a condition has to be explicit or implied. It doesn't have to take a particular form, but the cases that are very analogous to this one, Triple Diamond out of the 2nd District, M. Fabricant out of the 1st Department, and 730 J&J out of the 2nd Department, all discuss fully operational systems. The implication and the obligation being that the insured actually used the system. And that's uncontested here, that there was no system, not for a day and not for an hour, for a month.
And am I correct that your clients did not learn until the conclusion of the EBT of the defendant and his son on February 5th, 2019, that there was noncompliance with this particular provision of the contract, following which your clients then submitted a supplemental reserved rights notification, including the information that you learned during the EBT?
Yes, Your Honor. It was just shy of 2 months between learning that new fact and issuing the supplemental reservation of rights.
More than 2 months.
A little over
February 5th, April
Fair
15th,
enough.
but who's counting?
Fair enough. But, Your Honor, that actually speaks to the waiver argument that's being addressed by the appellant, which is also inapplicable, as the court in Provençal held, that a argument about timeliness of disclaimer and the detail of that disclaimer isn't relevant in cases not involving personal injury, and which fall under Section 3420 cases, and which is now Section 167 of the Insurance Code.
Right, because this court has typically not observed disclaimers that come too late on those type of cases, so that the case law and this issue that you have brought to the court's attention bears on that issue.
Exactly right, Your Honor. And moreover, not just being a condition precedent, the promise, the fundamental promise by the insurer to protect its premises and the property within it is a statutory promise under Section 3106A of the Insurance Code, and it's a common law promise.
Only they can do that.
That's
They
right.
are the holders of the property, and they are the ones in charge of that property.
The whole kit and caboodle, Your Honor.
Got it.
Thank you.
All right. You have 2 minutes on rebuttal.
I'll keep it brief.
All right.
Condition precedent is the argument. However, we maintain that effectively there is no condition precedent in this policy because the language of the policy is so fatally ambiguous. It again talks about an approved system. If the carrier did nothing to establish what the criterion were for an approved system, doesn't properly define what an approved system is, there are blanks in the very policy at question with respect to what an approved system is. And accordingly, we maintain there is no condition precedent, and therefore there is coverage. My client did not fail to satisfy a condition that, as a matter
We don't even have proof that this diamond is actually lost.
Well,
There's no proof.
that is
I
the-
don't have any proof in this record. I have an allegation that a package was sent from New York to Mumbai and this 29.8 carat rock just jumps out of the box and gets lost in a room. That's all I know.
Well, I disagree respectfully, Your Honor, because it's the testimony of the defendants and appellants here that the stone was lost. Now, that's a credibility issue,
Right.
an issue
And
of
he's
fact
got a
for the
video
jury.
he hasn't shown anybody.
Again, an issue of credibility. Thank you, Your Honor. I'll leave now.
I think you want a question?
Nope.
No? Okay. All right. Thank you. Smart man. Okay. Staff versus Lewin Nam Realty. You may proceed.
Good afternoon, Your Honors, and may it please the Court. Lily Pollack of the Price Law Firm for the plaintiff appellant Evan Staff. In this appeal, we're asking the Court to reverse the trial court's decision, which granted summary judgment in favor of the respondent and dismissed the appellant's complaint.
Well, it did so because it essentially undisputed based on the plans, based on the actual work done, that two discrete adjoining, notwithstanding there's a whole kerfuffle of what connected means, but adjoining one-bedroom apartments were combined so that they were roughly 500 square foot each. It became plus that. And there was a reconfiguration eternally where a previous kitchen and some other part of it became a second bedroom on one side. The bathroom was centralized, so that we have under the law a reconfiguration of the perimeter walls, and I use the term colloquially. I know there was no obliteration, but it's clearly not the same rent-stabilized apartments that existed before that. So confronted with that, and the law being very clear then that you were allowed a first rent, and the law then allowed luxury deregulation, that's the basis for dismissal. So why are we here?
That is not the reasoning for finding of the Court. It seems it's actually, the decision itself is replete with the reasoning. There were many reasons and alternative applications of the law that was presented by the respondent in terms of what deregulated this apartment, despite the fact that I might add that the answer in this case specifically pleaded, I think, in 3 different affirmative defenses, that these apartments are still rent stabilized. And yet now, at the motion to dismiss, motion for summary judgment phase, they're claiming it was deregulated back in 2013. Now, to your point of the plans that
So
were...
let me just, may I interrupt you? Your client wasn't in the apartment at all until after.
2 years after, in 2015, correct.
He has no personal knowledge about what happened. He doesn't, there's nothing, he can't say anything towards that, right?
Not to what happened in 2013 in terms
Well,
of
that's when
renovations.
the apartment was combined, right? That's when they're saying, so he has no personal.
The plans itself that they annexed to this motion.
I'm just asking you, your client knows nothing about it. So the only thing that you're doing is going on documents that other people prepared.
one, documents other people prepared, and two, the testimony of the respondent's principal, the owner, the sole owner. of
Right,
the
who
respondent.
clearly should have testified with an interpreter and didn't.
Correct, and was
Okay?
asked-
And so at the end of the day, seems to me that that testimony, in light of the clear difficulty with the English language, is of limited use. So I am more focused on the actual documentation that was within DHCR, what had been filed, and the proof of the actual changes to the apartment. And there is no question that there were two different units being rented to two different tenants for the almost the exact amount that was ultimately charged for the combined unit. So what's the problem?
I think there is a question of that. One, the record does
I
not
don't
have
see
any
a
of the
question.
leases.
Where in the record is there a question of that?
Page 73 of the record is the plans. It shows existing fifth floor plan, rear building. As it shows,
I'm
there is
talking,
one
counsel, we
door.
have leases from prior tenants.
Those
Are you
leases-
questioning the legitimacy of those leases?
No, but those leases were from after the alleged renovations. There are no leases in the record from before the renovations to prove that these renovations, this combination, didn't occur in the 1980s, as was testified to in the deposition.
No, that's
of
not
Mr.
what
Shin.
was testified to in the deposition.
there
What
was
he
one
said
door.
what he said was that the apartment was being used in a combined way. So it seemed like there was one entry to the apartment, but there were two units that were being rented separately. There were separate rents being collected by the landlord. That is clear from the record. That is clear from the record.
The appellant disagrees on the clarity of that from the record, but regardless of that, this court's case law in Dixon and Devlin, the standard of what constitutes obliteration,
So can we agree that there were two separate units that were being rented as two separate one-room apartments? Yes?
we do not have leases from prior to this alleged combination that show it was rented as two separate apartments.
There are leases of these two separate units in the record. So
There are
and
leases
you
in
were
the
not
record of
satisfied by them.
post-2013.
I'm sorry?
They're from after 2013, which is when the alleged combination occurred. Prior to 2013, there are no leases in the record that show that this was a rent-stabilized apartment 989RH lease
So
and rent-stabilized.
what are you saying, what is the problem with what happened, right? Let's say the wall was removed, the wall separating the two apartments was removed, correct? Right?
Correct, yes.
One of the bedrooms was removed. A new bedroom was installed where the old living room was there.
It was a reconfiguration. The majority of the plans show plumbing
you
work.
can, that's perfectly appropriate for you to sort of use whatever words you want to lessen what happened, but we all saw what happened. One bedroom was removed. A new bedroom was installed with the living room and the kitchen in the old apartment had been. The toilet and the restroom facilities were combined to create one bathroom, right? All of that happened. Do you dispute that?
I don't dispute that that's what they allege happened. I dispute that the facts and the evidence that's in this record was insufficient to grant summary judgment at this stage. There's just simply not enough in the record.
You'll have time on rebuttal.
Thank you.
Good afternoon, Your Honors. Robert Silversmith for the respondent.
Let me just start off with that. Is there any proof that the reconfigurations and all that I just stated did not happen?
No.
Everything in the record shows that those were the changes that were made to combine the two apartments, correct?
That's correct.
And the case law is pretty clear then, that when you expand the perimeters beyond what was existed before in terms of the smaller two one-bedrooms and make it a bigger two-bedroom apartment, which is totally different than what was before, case law allows a first rent.
That is correct.
And with the application of luxury deregulation on the vacancy, right?
Yes.
Then it deregulated.
That's correct. Are there any further questions?
No.
Thank you.
Thank you.
I would just like to go back to the point of the DOB filings. The filings that were provided in the record in this case in support of the allegation that this work was performed itself, one, I already mentioned the actual floor plans that show there was no door there beforehand. It was one unit, there was a wall in between. And the filing, the description of the filing reads, file combination of apartment 9 and 10 on the 5th floor, minor partition work, minor plumbing work, no change in use, egress, or occupancy. That is what is in the plans. Squaring that at a motion for summary judgment stage with an obliteration such that they are entitled to a first rent, that is the issue here. That is what the trial court did not consider and did not apply the facts and look to the record and see there are tribal issues of fact. The biggest tribal issue of
But Dixon makes clear that that when indisputably what existed before as two small one-bedrooms now become combined as one big two-bedroom, where the one door of one of the apartments was sealed off and became the wall. I mean, this is, the facts here are undisputed. The law is clear. When that happens, you don't need a gut rehab to make this a luxury apartment. You just need to expand the perimeter walls. The CAB did this back in the 70s, and the DHCR carried forward that policy, and the operational bulletins make that clear as well. I don't understand why you think it doesn't work that way.
our argument is not that this needs to be some sort of huge gut renovation, substantial rehabilitation, incredible apartment improvements to be entitled to the first rent. The issue at hand is, like you said, they sealed a door. They created two
What
apartments.
is the fact?
There's no
wait,
definition.
so that's what I'm trying to say. What is the fact issue that you think a jury has to decide?
When did these renovations and this combination occur?
Well,
There are
didn't the
so many factual
DHCR
inconsistencies in the
sign
record.
off on it?
The DOB signed off on the filings, but the filings were done, from what the record shows us, is the filings were done
And
to
you're saying that-
legalize something done prior
Okay,
to.
what are you saying, that we should not believe the DOB sign off? Why not?
No, we're not saying that not to believe the DOB sign
Well,
off.
then
We're saying
it's done. What is the
DOB
fact issue?
filings were filings to legalize work that was done decades prior.
You
And
have
this
no
landlord-
proof of that at all in this record. That's nothing but conjecture. You have zero. There is,
deposition.
tell me where in the record you have a scintilla of evidence that that these changes were done in the 1980s.
At the deposition, the defendant was asked repeatedly, and I understand Your Honor's position on the interpreter's lack of interpreter.
Counsel, I know that you read that transcript the way that I did, and it reads like someone who is not an English speaker.
I completely understand, and he was asked many times that his counsel and him waived that right.
Thank you. I appreciate
Your
your
Honor.
arguments. I truly do. JLJ Productions versus Amazon.com.
Good afternoon, Your Honors. My name is James Chinkway. I represent JLJ Productions. JLJ produced a show, an exhibition in the city promoting the artwork of Jean-Michel Basquiat called King Pleasure. They were approached by Amazon to produce a clothing exhibition. So they entered into...
But they were approached by Black Fashion
Black
Fair,
Fashion, correct.
right?
But Black Fashion said it was part
Who
of...
said they would who they were a part of Amazon, but it wasn't Amazon.
Correct, Your Honor.
Okay.
Correct. So the parties entered into originally what's called a main services agreement. And if you look at it, it just has general terms and conditions, and
It
basically...
has a farm selection clause.
has a farm
correct?
selection clause. There are really no obligations of either party in there. It just says that if you enter into a work order, this will be the term.
But the work order was incorporated into the MSA.
Well, no, because, Your Honor, at page 26 in the record, the MSA in paragraph 3.1 defines a work order. And it says a work order means any written order signed and issued by purchaser, which is Amazon, to supplier for the purchase of services under the agreement. It says it has to be signed and issued by Amazon. Amazon never signed the work order. It sent the work order to JLJ. JLJ signed it and
So
sent
then what contract are you saying was breached?
the oral agreement. It's embodied in the...
There's a contract here. You are the party to be charged. You signed it. You are the one. You signed the contract. This is the contract. This work order which is all the listed right here is signed by you, and you are the party there, and Amazon.com is not denying the contract. So that has nothing to do with Amazon.com not signing the contract. Does not make this work order part of the MSA, which has a foreign selection clause. You are suing under this work order for the work that's listed in this work order, and Amazon's not denying the contract. So you cannot get out of the foreign selection clause on that ground. Anything else?
Your Honor, they're denying the work order.
No, they're denying. They are not denying. They are denying that you did the work under this work order, right?
They're denying they ever entered into the work order.
Okay. So, and the MSA says anything that has to do with the parties' relationship, right?
The MSA says if there's a work order, then its terms govern.
Is any dispute arising under, in connection with, or an incident to this agreement? Very broad.
Which agreement, Your Honor?
The MSA.
The MSA.
MSA, no, the MSA was signed by my client, no doubt about it. I'm not denying.
So you agreed to go to Washington.
But it says, the MSA says that the work order must be signed by Amazon. Amazon did not sign the work order.
No, that's not what the MSA says. The MSA says if you have any dispute with Amazon.com about anything connected to this MSA, there's no doubt that your claim that you did work connected to this MSA. You didn't just walk up to Amazon.com on the street and say, here's some work I did with you. It was under this MSA, even if it wasn't under a specific work order. The MSA says that it has to be brought in Kings County, Washington, in connection with or incidental to this agreement. There's no doubt that what you did was in connection with this MSA, right?
Well, the court held that it was the work order was part of the MSA. That's the holding of the lower court. But in order for
Why shouldn't it be so considered?
Because in order to be part of the MSA, it has to be a work order defined in the MSA.
But it arises, as Judge Karspula just said, it arises from this MSA. And in the MSA, you agree that these disputes are not going to be litigated in New York.
Your Honor, the lower court...
Are you suggesting that your client would have engaged in any kind of contractual action outside of this agreement in the MSA? The entire reason why we're even having this dialogue is because there was an MSA between Amazon and your client.
That's correct. But that's,
And so your argument is because they didn't sign a work order, I should be absolved of the obligations of the agreement otherwise.
yes, because it's defined, work order has to be signed by Amazon. In order to be deemed a work order, it specifically says any order signed and issued by purchaser. They didn't sign the order.
Okay, we'll hear you on rebuttal.
Good afternoon, Your Honors. John Malieri for the respondent, Amazon.
So before I forget, why isn't he right? Is he wrong that there was no work order? And if there was no work order, why isn't he correct?
There's three reasons, Your Honor. The first is they brought the complaint under the work order. They can't pick and choose which provisions they want to enforce. Paragraph 24 of the complaint, JLJ and Amazon entered into an agreement embodied in the work order. This is a breach of contract case. How can they say we agreed, we're enforcing the contract, but we don't like this provision?
Well, doesn't the MSA have a specific provision at 16.10 that says that the MSA, together with all orders issued, are incorporated and made part of the MSA?
That's the second reason, Your Honor. Yes.
Let me just make sure that we agree that plaintiff is alleging in its complaint breach of that work order.
It has to be. It's
not an oral agreement because that they met on the street. The complaint itself, because the counsel said that it was an oral agreement. I thought I read the complaint that said that there was a breach of the work order.
They say that they entered into a contract for $250,000 to put this thing on, and that's what they're suing us under. That has to be what they're suing us under. They tendered back a signed work order. The second reason, Your Honor, Your Honors, that it's enforceable is if you go to 1.1 of the MSA, it says that the services include any purchase or work orders issued or signed by purchaser. And that same idea is carried through in section 3.1, which says, even if we don't sign a work order, it still constitutes a work order if you do the work under the work order. So Amazon's accounted for the idea that it may not sign. And then the third reason, which
And there was work done under the work
they
order.
claim they put on the performance. That's
Right.
what they're suing about.
Right.
And then the last reason is the reason that Justice Friedman's already identified, which is the extremely broad scope of the governing law, venue, and jurisdiction provision, AVNet, which this court decided about whether an unsigned work order is still part and parcel of an MSA. This is broad. It says anything about this agreement or incident to this agreement. To invalidate the forum selection clause here would invalidate an extremely common form of contract, right, where we have a master services agreement and work orders.
And our jurisprudence would certainly include a work order under incident 2.
That's correct, Your Honor. Thank you very much.
Thank you.
Your Honor, there's also a fraud claim here. It's alleged that JLJ was defrauded into doing all of this work. They were strung along. They were told that the work order had been signed. They told it will be signed. They're spending money. They spent
You know, but at a certain time, your client, and I have empathy, okay, so be clear. But at a certain point, you see that you're spending, you're getting nothing back.
We're getting promises. A week after.
Yeah,
we
well,
signed it, they said-
promises don't, I can't put promises in the bank,
Well, it's fraud, Your Honor.
right?
The
So,
fraud claim is subject to the venue provision also.
Well, I respect.
I know you don't agree, but we'll make that determination. But
Actually, I
if we
have
were
to
to
go with what you
conclude that
say, Your Honor, but-
if we're to conclude that the breach of contract is barred by the venue provision, then the fraud provision is going to have the same problem.
Right, because anything that's incidental, which a fraud claim, fraud in entering into the work order is clearly incidental to the MSA. It's
Then
covered under,
there's no distinction then if they signed it or they don't have to sign the work order.
I mean, that happens all the time, and you cannot get out of the, that's what I'm saying.
especially if you have a specific provision in the contract that says that. So you're only out, your client, not you're only out, your client's only out was to not perform because they had not signed the work order, and then we'd be in a different position. But your client acts upon the work order. By doing so, they basically validate the work order.
No, they were strung along, Your Honor.
I
had no choice.
understand. When I empathize truly, I do. Thank you. Have a good day, gentlemen. People versus Donald O'Toole. Last but not least.
May it please the court, Alma Gonzalez for Mr. O'Toole. The court should grant suppression and dismiss the indictment in this case.
Counsel, why shouldn't a radio run, which says a gunshot fired, the immediate meeting of the police with your client in the hallway, the smell of gunpowder, the quick visual of the bulge in the waistband, I'm being overly simplistic, but I'm cutting to the chase. Why wouldn't that be a level 3 because you're arguing they went too far. So I'm saying, why wouldn't that be a level 3? And then, of course, with the flight and the rest.
So I think two things to note there, Your Honor. The first is that I know that they arrived at the building pretty quickly, but they walked up 9 flights of stairs, which takes a long time. So this is very distinguishable from cases where the officers
For some people, for me, it would take a long time.
for me as well, Your Honor. That's
I will admit, for me, it would take a long time.
Yeah.
But let's say, so look, we as the appellate court are kind of, we are considering the findings of the court below. And the court below credited the officer's testimony that when they arrived at this 9th floor, that they could smell gunpowder, and that the only person, to me, that was really significant, that the only person in the hallway was your client, and that they observed that he was engaged in a conversation with someone in an apartment who, when they saw the police, immediately just shut the door on you, slammed the door on your client's face, left your client in the hallway. And that your client turned around and started walking toward the elevator when they engaged him in conversation, right? We can agree that they certainly had a right of inquiry based on that, correct?
Yes.
Okay. And then the evidence in the record, based on the hearing testimony, is that the officer engages him in dialogue, and that at a certain point he says to him, he says he observes a bulge in his waistband and informs your client that he has to pat him down for safety, and that then your client runs. Why is that observation of a bulge in the waistband, based on all the other information they have, the smell of gunpowder, a radio run of shots fired on the 9th floor, he's the only one there, why doesn't that get us to level 3?
Well, the bulge wasn't in the waistband, it was in the pocket, and the Court of
Well,
Appeals.
the gun was in the pocket, but he had something that covered him, right?
Well, Officer Pimentel specifically said that he observed the bulge in the right pants pocket, and the Court of Appeals has said.
I thought he said in the waistband, and that the gun was recovered in the pocket.
No, he says, and let me see if I can find.
Tell me, because
page
I'll look
here.
again, but I thought that's what I read.
He says on pages 33 to 34, specifically on page 34, he said, he's asked, right side of what, with respect to where the bulge was, right side jeans pocket. And so an undescript bulge in a pants pocket is very different from a bulge in the waistband, which typically indicates a weapon. I don't disagree with that.
Okay.
And so, the gunpowder.
For just a second, Pimentel noticed a large bulge near defendant's waist. That's what he testified to, right? And then, which was pushing a big portion of his jacket out. That's from 31, 33, 34. That's when he said, I need to frisk you for safety. So it wasn't, at that point, he said, I noticed a large bulge near defendant's waist, which was pushing a big portion of his jacket out. That's not in his pants pocket down by his thigh.
Well, that is indeed what he ends up.
Well, that's
clarifying later.
what the testimony is, the hearing testimony, 31, 33, 34.
Right, but on 34.
Let's assume that was the testimony, right? That would justify the pat down, right? It would go to a level 3.
Presumably, but again,
So if the court credited that testimony.
But that's also the thing, Your Honor, is that the court did not make a finding as to that. The court specifically said in the footnote, inconsistencies between the two officers' testimonies irrelevant to the finding. And
But the inconsistency between the officer's testimony was about whether your client was pressing the button a lot to get off that floor, or whether he pressed it once.
There were various inconsistencies, the bulge being one of them. Officer Pimentel testifies that he saw a bulge. Officer, I believe it was Soriano, does not testify to seeing a bulge at all. The defense disputes that.
Do we know from the transcript where Soriano is standing? I would imagine that they're standing on either side of him. So
Right,
if the gun is on one pocket, the officer who's standing on the opposite side of him would not be able to visualize that bulge, right?
So Officer Soriano actually sees most of this interaction, sees our client walking out of the apartment, is there at the elevator bank.
Walking out of the apartment?
That's what Officer Soriano testifies to, yes.
Okay.
Officer Soriano testifies that he gets out onto the hallway, sees the door open, and then later on, he gets onto the hallway, sees the door close, goes around, then sees the door open, our client walks out, and then the door closes. So that is a difference between the two, but like I was mentioning, at the time, the ruling is that at the time that Officer Pimentel arrived in the hallway, he had reasonable suspicion to search, but at that time, all he had was the radio run, the smell of gunpowder, and our client and another person present, and that
Okay,
just doesn't.
But that wasn't the ruling. The ruling wasn't that upon arrival on the 9th floor that he had a.
Oh, it was, Your Honor, and I'll quote. I can find the page. On the first page, at the bottom, the judge rules, based upon a totality of circumstances, P.O. Pimentel had the requisite reasonable suspicion to detain the defendant, quote, upon his arrival on the 9th floor. That was the ruling. And at that time, they're just.
Right, a reasonable suspicion to detain him. And then he sees the bulge, and then that rises to the ability to search him.
Well, the court does not make a finding that there was a bulge here. So I would argue that LaFontaine bars this court from considering that. Thank you.
Got it. All right. You may proceed.
May it please the court, Stephen Levy for respondent.
Based on your adversary's last statement, is that your argument that upon arriving on the 9th floor, that he had sufficient basis to do a full-blown frisk?
So 2 points, Your Honor. Under Moore and Brown, there could be an argument along the lines of what you've just summarized, that upon arrival, there was reasonable suspicion that a crime had occurred, perhaps even to do a frisk. But here, we need not rely on that because other factors, as highlighted in our brief, including the bulge that we've discussed, were also present. So upon arrival, the officer did not immediately go for a frisk. He actually exercised a good degree of restraint. He observed the situation, the strange interaction with the door closing, the kind of incongruous answer he received that the defendant was visiting a friend, which did not
So
jive.
is that
Go ahead, Your Honor.
response that even if this court disagrees that upon arriving on the 9th floor, that because, as you say, the officers showed restraint and went through the Dubois steps of doing a common law inquiry first, that then got escalated by the defendant's actions, that we can still reach the same determination, notwithstanding the court's perhaps misguided statement?
Just clarify the very last part, Your Honor. The court's misguided.
Yeah, that there was a reasonable suspicion for a full-blown search upon arrival on the 9th floor.
I see what you mean.
Which I don't see.
Yeah, to clarify, my understanding of the court's decision is the split you've identified, Your Honor. Upon arriving at the floor, the reasonable suspicion that a crime had occurred, and therefore reasonable suspicion to detain. She then goes on to say in the next sentence, the interaction then led to the attempted frisk being appropriate.
She didn't specifically say it went from 2 to 3, but I think that that's a pretty fair inference from the decision itself.
We would certainly accept that, Your Honor.
Let me just ask you this.
The outcome.
The question is, I thought the testimony, not that he saw something in the guy's pocket. I thought he saw a bulge near the waist. That's what my recollection. I remember going back and looking at
Yes,
the
Your Honor.
transcript.
I can
Bulge
provide-
near the waist that stuck out of this big weird thing that he had over. Is that
Yes, that's correct. I can provide pin sites as well to help, Your Honors. My brief has these, but I'll just provide a small summary now. If you look at pages 31 and 33 to 34 of the suppression transcript, that's where the arresting officer, Pimentel, expressly says that he saw a bulge around the waist, which in Your Honor's precedent and the Court of Appeals precedent, that's a telltale sign of a weapon. To clarify, when the gun is ultimately seized, it's a very, very large .45, and it was in fact in the right jeans pocket, but it was creating a waist bulge. So when he arrived at the
Depends
scene...
where the pocket's located.
Sorry, Your Honor?
It depends where the pocket is located in the pants.
Yes, and the size of the gun as well, which may create...
And what coat? Because this happened in
mid-November,
right?
Your Honor. Yes, the coat was heavy, as the record shows, even for that season, because it was a nice, clear day. I can also briefly respond to the LaFontaine point, which may help Your Honor's guidance. There's 2 main points to make. First, the testimony concerning the bulge, as well as the other factors we discussed in the brief that weren't expressly highlighted by the court below, those were not contradicted. So the bulge, for instance, Officer Soriano, who was a defense witness, he was called by the defense, not by the people, he just was not asked any questions about the bulge. It simply never came up. So when you look at is his testimony disputed, there's no dispute on the actual bulge.
And was there any dispute that the person in the apartment slammed the door shut?
There is no...
Shut the door?
So the only
And the police
factual...
came up?
Yeah, Officer Soriano had a slightly different recollection of that. It's not terribly different, though. Essentially, he had said when he arrived at the 9th floor, he too smelled gunpowder, he too saw the defendant, but he observed momentarily that door closing and then a moment later reopening, at which point defendant stepped out. So he heard the door close as he's coming on the scene, and then a moment later, the door reopens and defendant comes outside.
And then the
I'm
door
sorry,
closed
Your Honor.
again or not? Because the door closed again?
After the defendant had stepped out.
After the defendant
Yes,
stepped out.
that's right. But he was, the positioning is also laid out in our brief of the respective police officers at the scene. Pimento, the arresting officer, essentially has like an eagle-eye view of what's happening here, and he's the main interactor. The second point, though, Your Honor, just on the point about LaFontaine, People v. Garrett is also relevant here, the Court of Appeals decision from 2014. I'll just give you the site. This is 23 NY 3D 878. Your Honors may be familiar with People v. Garrett just because it was a major decision limiting LaFontaine's reach. The case stands for the proposition that when you have a single, multi-pronged, multi-factor test, the court is free on appeal to take account of the whole totality of circumstances. It can even consider, if necessary, not that this is necessary here, alternative theories about why those factors are satisfied. So applying that case here, whether a frisk is reasonable, here an attempted frisk is reasonable, is itself a multi-pronged inquiry. Was there reasonable suspicion? Assuming there was reasonable suspicion, was a frisk or an attempted frisk appropriate? So because you're dealing with this kind of multi-pronged test, you're free to consider the whole record, even if the lower court didn't expressly unpack, in its 2 or 3 paragraph decision. It's a whole analysis. Thank you, Your Honor.
Thank you. You have 2 minutes on rebuttal.
I will start there. So one, this is not just, the lower court forgetting to include this finding. This is the court expressly saying, these whatever inconsistencies the defense has raised, irrelevant to my holding here. I'll note also that the people below did not, in their arguments, even rely on the bulge at all. I'll also quote from pages 33 to 34. This is from Officer Pimentel's testimony.
Do you disagree with your adversary's last statement with regard to our ability to review the entire record as a whole and make our own determinations?
No, Your Honors, I would agree to that, but I would say that this scenario is very different where, again, we have the lower court specifically saying that this did not impact the ruling here, the ruling that we're trying to appeal. And so we would still argue that
This minor discrepancies in the testimony didn't affect her credibility determinations. We basically say that all the time in the trial court when we're trying the judges.
Well, she does find both officers credible, but then the task in making the findings of facts is to resolve some of the relevant facts to the ruling, and she did not resolve that discrepancy or a number of others, including
I'm not really sure why that's a problem, because, two people, if you sit in the trial court long enough, you realize you never testifies consistently 100% of the
right, and we're not arguing that the officers weren't credible.
You just finished.
Yeah, sorry.
It's not that hard for a judge to say, I don't find those inconsistencies to affect my decision. That's a pretty common thing. So I'm trying to figure out, why are you raising it?
Well, because, under LaFontaine, the statute that it evaluates, in order for this court to be able to consider those factors or those grounds, it has to actually adversely affect the appellant, and it did not in this case. And, the last thing I'll say is, even if we consider the bulge, this was a nondescript bulge. This wasn't described as an L-shaped bulge. This was described as being in the right pants.
But we can't ignore the context of it. They smell gunpowder on that floor, and they're brought to the 9th floor because of a report of shots fired on the 9th floor of this building. So I agree with you, and I have written decisions on that issue that that an undescript bulge is not enough. But we don't just have that here, right?
I understand, Your Honor, and
Yeah.
I think that there's certainly a reasonable suspicion to believe that a crime had occurred, certainly, but reasonable suspicion for a search requires more. It requires proof, reasonable suspicion that our client in particular was involved in that, and there was just nothing here. He didn't try to reach for his waistband. He didn't try to use it or indicate in any sort of way that the bulge was coming from a gun, as opposed to, for example, all the cash that he had on him, plus the 2 cell phones, plus his wallet.
Yeah.
So I'll
Okay.
rest there and
Thank you
guys
so
for
much.
your
Have a
time.
good night, both of you.
Thank you. I'm sorry, my hand is so cold. Thank you. Remember, was it you who said that your sister was getting married? How'd that go?